The live video has resumed. We lost our Wi-Fi for a few minutes. We have lost everyone who is watching. Ironic that I was talking about the shortcomings of electronic devices in court, and then mine failed me. We'll wait to see if anyone has found us here. Apologies for the interruption. I got a message that the bandwidth was far too low and we were out. I'll just backtrack a bit. We're talking about the presentation of electronic evidence in court. Many folks have these videos on their phones. The advantage of a laptop or a tablet is, of course, the larger screen, a little easier for everyone to see. And then if you have it in a format such as a thumb drive or a CD, then that physical medium would be the exhibit after we've watched it in court. I have on occasion watched videos on a phone, but I will say the same thing here that I say frequently, it appears in court. There really is no good way to preserve in evidence what is presented on the video. So if it is relevant, if it's important, we will have you go ahead and play that so I can see it, the other party can see it, but as you might imagine, it is not ideal. And then that's it. I will describe what I'm watching on the phone, but there is no way, again, to preserve that, especially if there is an appeal. We'll talk about appeals here in just a moment. I'm going to pause again, make sure that folks are able to find us again. As you might imagine, there are any number of types of electronic evidence, videos or still photos that might be of interest in a small claims case with a motor vehicle collision as an example, photographs of the, and now folks are coming back. I apologize again for the glitch. I think it was on our end here at Yakima County. I was dropped as I was told my bandwidth was too low. What people have presented in the past very frequently would be photographs of cars that have been damaged, damage to other property, if that's at issue. We do see surveillance videos from time to time. They may be of interest. Videos of other evidence that may be just cumbersome or by its nature can't be produced in a courtroom. Any number of ways that can be relevant and important to consider. I'm pausing now and again as people are trickling back. It is vitally important in the presentation of your cases. I was talking about how tempers can flare, and just because of the nature of a dispute, there may be a great deal of unhappiness, frustration, and whatnot. In the courtroom, you must keep your temper, hold your tongue, and approach the case with the best of manners to the other parties, the other participants in the process, including court staff. I will tell everyone involved that everyone gets to speak their piece, but only one at a time. Interruptions of other folks who are talking is one of my absolute pet peeves. It is rude to the other participants. The more practical difficulty when two people are talking at the same time or there are interruptions is it does impact the quality of the recording of the trial, and it makes it very difficult sometimes later on to sort out who is speaking. So one at a time, do not interrupt is my absolute rule. You will get a chance to speak your piece when it is your turn, but do keep your comments as calm as possible. It is not an argument when you are in any trial, not just small claims. It's not an argument with the other party or with the court. You are trying to persuade me. The wisdom or the nature of your position and why it should prevail in that trial. And the more calm you are, the better organized, the better your presentation will be, the more effective your presentation will be. Again, for the most part, lawyers are not involved. It is just the parties and the witnesses and me. You want to do the best that you can in keeping it as businesslike and amicable, I guess, as you can. More folks are trickling back. If there is the conclusion of a trial, I've already spoken about, sometimes I will rule from the bench right then and there and enter a judgment, and we will distribute it to the parties. More often, if there's any quantity of evidence, I will take that with me and render a decision within the 2 to 3 weeks that I discussed earlier. Then, if you are the non-prevailing party, if you are disappointed in the decision of the court, depending on when or whenever it's rendered, you may have the right to appeal my decision to the Yakima County Superior Court. If you wish to do that, there is, again, a form for a notice of appeal that you would file with our civil division again. There is a filing fee for any civil appeal. and you must serve that appeal on the other party again. So there's a similar service process that you'd go through to alert them of the appeal, the basis of the appeal, and then they have an opportunity to respond. There is a period of 30 days after a decision is final in our court, during which you would have to file an appeal. If there is no appeal filed within the 30 days, then your right to appeal goes away. There is that limited window of opportunity. You have some time to think about your options, but it does expire in 30 days. The appeal is heard by the Yakima County Superior Court, and the appeal is a little different from what is most common with the appeal process. The court would review the same evidence that I saw and heard in the trial. There would be a transcript of the proceedings and the evidence, the same evidence that was admitted in the trial process itself. They will decide whether or not they would have come to the same conclusion based on that evidence. In the appeal, there is not new evidence introduced. It is limited to what was considered, what was before the district court judge at the time of the trial. I don't know how many folks we have in. I'm going to pause. If anyone had any questions, you can type those in. I'll try and respond to them as best we can. I think we lost a number of folks with our little glitch. Okay, we'll keep moving. Talked about the appeal process. We talked about evidence. I do want to talk a little bit more about the jurisdiction of the court at this level. At the outset, I described the small claims action as an informal one that is, again, designed for more expedient resolutions of cases with lower amounts at issue. There are certain things that the court can't consider. The court doesn't have jurisdiction over in these types of cases. Nothing involving real estate can be determined at this level. The court cannot hear claims for defamation, libel, malicious prosecution. There are some very specific items that cannot be decided here. Small claims actions are for money judgments only. That is the only thing that can result at the end of a small claims process. It's a judgment for money or a judgment for the defendant, in which case there is no money at issue. It is specific amounts. What I would suggest is whatever plaintiff has had to pay out of pocket, whether it's repairs for a car, repairs for other property that's been damaged, money that has been lost because of breach of a contract. The most frequent type of case that is heard in small claims cases involves deposits on rental properties, apartments or houses. The parties are disputing whether the landlord, as an example, should have or should have returned some or all of the deposit, or whether they were in error with the settlement. But it always involves a very specific amount of money. I cannot enter a judgment for pain and suffering, for emotional anguish as a result of the acts of the defendant. Those are what we would call non-economic damages. That does not mean that you may not be entitled to those types of damages, but that type of claim would have to be filed in Superior Court. What a small claims judgment is intended to do is make you whole. Have you lost money because of someone's negligence or breach, otherwise a violation of an agreement, and that can be reduced to a specific amount of money. The jurisdictional limits we talked about, $10,000 and $5,000, are just that, limits. Just because an action is filed may not mean that you're entitled to that amount of recovery. The plaintiff has the burden of proof, must prove what is owed by preponderance of the evidence. That is about it, the overview of the small claims process. Again, if there are any questions, I think we lost a lot of people during the glitch. I know we have at least one or two watching, but let me know in the next couple of minutes if you have any questions. Otherwise, we'll bring this to a close. Okay, thanks folks for your attention. I hope it was somewhat useful to you, and we'll finish the video.